Hello and welcome you to our series about intellectual property. My name is Kamran Houshangpour. I'm a patent expert and IP trainer, and I will, in fact, be with you through all these stages, starting from today's introduction about IP rights, among which we are going to talk about what is IP rights and what IP rights we know and so on. And then, of course, in order to prepare a little bit for further lessons to come, that is actually a deepening in patent rights. And then, last but not least, we are going to talk a little bit about IP searches, especially about the patent searches, which is of most of interest for all of us. As I told you, I'm actually patent expert and IP trainer at the IPI, that is Institute of Intellectual Property. That is something like Switzerland's patent office. Uh, with the exception that there is no patent office in Switzerland, it is the Institute of Intellectual Property. So it is somehow comparable to your own patent office in your own country. I'm a patent expert. That means, in fact, that part of my time is dealing with patent examination and patent searches. That is why I will also be allowed somehow to talk about these topics: what is a patent, how to search a patent, and so on and so forth. Another part of my life is, at least my uh, professional life, is dealing with IP training. So I'm going around the cities. Sometimes I'm lucky, I go even to other countries. I were lucky to be at least twice in also in Indonesia to talk about the IP. This time the luck was not on my side, so I'm going to talk only about these topics through these videos. But I hope that it is nevertheless something which might interest you because the subject as itself is quite interesting. So, what are we going to talk today about is about, let's say, uh, what is, in fact, the intellectual property. So, at the beginning, I'm going to talk about why the humanity came to a system like the intellectual property system, why the need was there that people had to interfere and invent such a system which was not out there. So we will talk about that, why this intellectual property system became almost necessary and how it came to the world. Once we understood a little bit why it is like that and how it works, that gives us the possibility to talk about different intellectual property rights. We will see that there are different types of them. Some of them are, of course, the type of registration rights, like, for example, trademarks, industrial design, or patents. Some of them are even free of registration, like copyright and so on. So, what are the differences between trademarks, industrial designs, copyright, patents? And then there are also maybe other registered rights. We will see that there are also other possibilities to register some rights which are not maybe patentable, which are not are eligible to be registered as a trademark and so on, but maybe it is quite important for you also to know them. Then, are there any other possibilities other than these registered rights? Of course not. Nobody tells you that you have to register your right. You might keep it secret. So the secrecy is also one of the topics which is of interest, and we're going to talk about it. And then most of the countries knows some other possibilities of protection, which is unfair competition laws. So, depending on how the law in your country is, you might have also these possibility in order to be protected. However, we'll see there is a huge difficulty in using unfair competition. Sometimes you are obliged to use that, but you will see that if you have the possibility of registration, that is the easiest way, in fact, to protect yourself. At the end of this topic, I will give some words about IP strategy and IP cost. So you will see that despite working for an intellectual property office, my idea is not to oblige anybody to, in fact, have an IP right. So it is not, let's say, a necessity to ask for an IP right like patents. But what is necessary is to have an IP strategy regarding what you are doing, regarding your part of business. So, because without an IP strategy, you will certainly have problems. Without an IP, I don't know, you might have problems or not. It depends on exactly your IP strategy. And these IP strategy is also partly dependent, of course, on the costs. And you will see that, in fact, some of them are very high, but they are maybe justified. You might, in fact, take into consideration that without that cost, you will have much more cost to pay. So let's start to talk about what is IP and why we came to that. Let's say everything started with a good idea. In some 2-3 minutes, I will tell you the idea cannot be protected. But let's start because everything starts with a good idea, of course. And the idea is, in fact, here, the good idea is this peeling device that you might know. All of you have seen one of them, which helps you in your kitchen to peel your vegetables. So that is actually at the beginning. Now, if your good idea is has a value, and that by value I mean actually has a let's say economic value, and this value is such that you earn money with that, so that is a sort of cake, if you want, out there, that you can benefit from that cake, you can be sure that if there is an economic value, everybody else would like to have a part of that cake. So if there is actually no economic value, you are fine enough because nothing to share. So nobody's actually interested in that. But if there is a part which might bring some money, some economic value, then it becomes interesting for everybody. And everybody wants to have at least a part of that economic benefit. Now, the question is actually, what is then with your right as being the first person having that good idea, or having realized, better said, having realized that good idea, because just having that idea is not enough. You have to realize it. So if you had actually a very first sort of realization, like the one we are seeing here in the very first picture, what's about your rights on being the very first one? All other guys which we are seeing here are just somehow copying you. Okay, but even those guys, if you look thoroughly, you will see they are not really copying you one by one. Each of them might have also some specific aspects. What about their rights on their specific aspects? So I have to say that actually all of them have at least one thing in common. That is a technical thing, which means, in fact, having two parallel blades, which is used for the peeling of vegetables, for example, and these parallel blades are perpendicular to the handle, and the handle is in fact determined by the direction of peeling. So you have actually, they all have two parallel blades perpendicular to the direction of peeling. Uh, all of them have the same possibilities except for the last one, the red one on the right side. And there you see, in fact, that this one has even more than these possibilities, because you can actually decide if you have it in the perpendicular way or in a parallel way. You have to can have it actually two blades parallel to the direction of the handle. So it is actually is going even beyond your idea, but he has also your idea in it. So uh, again, without this first idea, this one would not have been living. But he has something more. Or the other ones, if you are looking through them, they would have something else, because maybe aesthetically they are different. What about their rights? Can everybody copy everybody? And why is it so difficult? And why shall somebody talk about these rights, these, let's say, intellectual idea rights today with you? I mean, most of us had some experience about selling things or buying things, and we did not want anybody tell us how to sell things or how to buy things. Why is it so difficult that we are talking about selling or buying ideas? So let's think about what is the real challenge with regard to this new idea. So why is it not that easy to just go to a market and sell your idea? But start with selling things, as I told you. Let's say actually, let's imagine that I'm living in a countryside and I have some chicken, and these chicken actually lay some eggs. I don't have them, but let's imagine it is like that. So I have 6 eggs and I want to sell those eggs. What happens? Well, I can go to the market and I will ask people who wants to buy these eggs. If I offer the eggs to a normal, reasonable price, people are interested in my eggs and they want to buy that. So what happens, in fact, somebody comes to me, give me the money, and I will give him back the eggs. So at each moment of the time space continuum, I either have the eggs or the money, and the other guy has vice versa, either the money or the egg. So we are going to do a real exchange. I give him the good and he will give me in return the money. So in that case, we are both happy because we can go back. I will have actually my money. I can do whatever I want with the money, and he can actually have his egg. So he has something to eat today. So that is the good thing. It is even better because if this guy, for example, does not like the eggs, or he once he came at home, he sees that the eggs are not that fresh as I told him, what happens? He can come back to me and say, you told that these are actually fresh eggs. I went home and it seems they are not fresh. I don't want these eggs. Please give me my money back. What happens then? No problem. I can give him his money back and I will have the eggs again. So I have actually the goods at least, and he has the money. Again, there is an exchange in the other turn. So we can handle it among adult people, just among us. We don't need any country, we don't need any state, we don't need even actually the interference of law in that interaction, because that is an interaction, that is a transaction that can be done among adult people which can reasonably talk to each other. So, in fact, maybe many of states and systems are not very happy if you're doing that because they do want to have their VATs, that is actually value added taxes. But okay, that is the problem of the state, that is not a problem of both of us. So now let's think about a second, let's say, possibility. I come to you and I tell you, I have a wonderful idea. The idea is, in fact, to make an egg stay on the table without rolling away. How much money you will pay me for that idea? So, normally, you won't pay anything because you cannot be sure that I'm telling the truth. So in best of situation, you will ask me to show to you how it works. So show me how it works, how your idea works, then I might give you the money. So then I will show you my idea and how it works. As you see here on the figure on the bottom of right side of your screen, that is the solution I have to make an eye stand without rolling away. So I put it, quite hard on the table so that it remains on the top of the table without rolling away. Now the question is, in fact, so now that you know how it works, why should you pay me? I mean, you don't need to pay me anything. And you have even a good argument not to pay. You can always say, yeah, why shall I pay to you for something which you have still? I mean, by exposing my idea to you, I did not lose the idea. I mean, that is not like the good I gave to you. I have still the idea, of course. I expose it to you, but I still have it. So why shall I pay to you for something that you did not really lose? You have still that idea. It is even worse. You can tell my idea to everybody else so that everybody else can use it, and I still don't earn 1 cent for that. So that is why it does not work in that way. So the point is that actually, why did not why didn't you pay for that? I mean, why nobody was willing to pay something for that? Because in that case, uh, you are better off. You can have the idea without paying anything for that. The bad thing about this situation is the situation of the one who has this genius idea, because he has no incentive to do further such sort of invention. So you lose that incentive to make innovations and inventions through this system. Even in the case if you have paid for that, if somebody were eager to pay in order to know the let's say the solution before I exposed it to everybody, uh, when he paid for that and I did actually my exposure, now he's not very happy with that idea and says, actually, the idea is maybe nice for you, but I don't want to have some egg on my clothes before I'm going out. So I don't like that idea. You don't, so give me my money back. The problem is actually how to be sure that he did not like that idea. I cannot erase the idea from his head and then somehow, in fact, okay, now I give you money back. It's not possible. As you see, there is always a problem with that type of transaction. You cannot have that sort of transaction without these problematic. There is no possibility as having a transaction as we had it in the case of exchange good against money in that system. And that is not possible to solve that problem among adult reasonable persons. So that is why person needs somehow a help from outside. These help from outside uh, came as, let's say, a sort of a system, and this system is called the IP system. The IP system is almost all over the world in the same manner. So it works more or less the same for almost all the countries in the world. Uh, it is a system based on an exclusive right, which is given to the owner of the right, and that is a right to prohibit third parties of using it commercially in the territory where the protection is granted. So now the question is actually, what is an exclusive right? What can be done once you have that right, and where it applies? So first thing is, in fact, an exclusive right is just the right to exclude. And the IP system precise that is not an absolute exclusion. You can exclude commercial use. What is commercial use? That is somehow given in a list which is not exhaustive, but it shows more or less what it is. For example, to produce is a commercial use. To make a commercial use of, to make publicity for is a commercial use. To put in sale is a commercial use. To put in circulation, which means even actually to give it as a gift if it is for a commercial purpose. To import it, to export it, under some circumstances, even to make a transit. And then where does it apply? It just apply in the territory, in the country, or the countries where the right is granted. In other words, a patent, for example, in Indonesia does not bother anybody to produce it in Malaysia and sell it to Singapore. So if you don't want that it happens, you have to have at least a patent in Malaysia or in Singapore. The best is actually to have a patent also in both other countries. So that means, in fact, your IP right is only valid in the country where it is applied for. So if you apply for the right, for example, in Switzerland, that does not mean that the right is also valid for Germany and for France. Then this exclusive right also is very important because it is something which is dealing only with, let's say, the exclusivity. An IP right on its own does not give you automatically the right of use, if you want. It just gives you the possibility to exclude third parties of a commercial use. So once we know about that, we have to think about actually which aspects can be protected through which rights, because there are different types of IP right. So some of them are dealing with, let's say, communicative aspects. The communicative aspects are in fact dealt with by the IP right, which is called trademark. Then, if there are some technical aspects in the innovation, these technical aspects are in fact related to a patent. If there is something about some aesthetical aspect that is dealt with uh, during the framework of the industrial design. And then above all of them, it is of course not only let's say these registered aspects. If your idea has something, let's say, uh, artistic or something which is part of literature, these creation dealing with the work of literature or of art is also protected by copyright. So that is actually the artistic aspects which are covered with by a copyright. So IP rights are nowadays actually a part of our life. If we want it or not, that is something we are facing every day. So even in everyday's life, when you take your coffee, for example, I hope that you had your coffee today. So if it was from a coffee machine like the one I show you here, depending on which situation you had, you might have had seen 3 to 4 different types of IP rights. So maybe these coffee machine worked. So in that case, you had something which is functioning. So that is actually technical aspect of the machine. If the machine works and it functions, these technical aspects is in fact protectable by some IP rights. We are talking about it. It is actually nothing else than the patents. Then the machine has normally actually different names. I see here, for example, even two. One is starting with an N and ending with espresso, which is actually an espresso, and the other one is Krupp. So uh, a name in order to distinguish these goods and services from the goods and services of other company. That is another aspect. That is an aspect of communication. That is like you introducing yourselves to other people with your name. So that is actually, in fact, nothing else that a communication way of presenting yourself. These aspects also in a let's say economical environment can be protected, and the protection is coming in fact from an IP right, which is the trademark. Then the machine has normally actually, let's say, an aesthetical view. The reason why you might have chosen this machine, I don't talk about the technical possibilities of the machine, that it has a pressure of 15 bars, or can, I don't know, do some let's say special sort of coffee and so on. That is not that what I'm talking about. I'm talking about just the aesthetical form, the form of the machine. Most of the time, in fact, there are different machines doing exactly the same thing, and you chose one of them because you found it maybe more beautiful. I don't know, maybe because it fits better to your design, interior design of your house. So that is these, let's say, form aspects, these aesthetical aspects are also protectable. And if the coffee machine did not work, did not function, then you might have take a look at the manual. And depending on how that manual is done, it is also the manual is also somehow protected, and that is a protection by copyright. So patents, trademarks, design, and copyrights in our everyday life, and we are living with them if we want or not. And the idea of today's let's say introduction is not to say you have to have one of those rights, but the idea is you are in fact facing those rights. So you have to know them and you have to learn to live with them. And that is the main message I want to give you to you. Not a message to incite you to go and make some registration, but to know what are your rights and what are your duties in front of such sort of registrations. So these different IP rights are also somehow categorized, and due to these categories, you can find different scope of the IP right. So in let's say in the blue part, you will see everything which is normally non under IP rights. That is actually, for example, in general, the protection of intellectual property, which is divided into unfair competition law and intellectual property rights. And when we are talking about intellectual property rights, we have on the one side the registered rights. These registered rights are called industrial property, and of course, another part of intellectual property rights, which is actually copyright, and which is not need to be registered. You have the copyright, in fact, by the creation, but it is still actually a part of in fact, the intellectual property rights. Under the industrial property rights, you might find different types of intellectual property, for example, patent, trademark, design, but also other parts like topographies, which is the layout of design of integrated circuits. You might find also geographical indications, which is, I'm sure, very important also in your country, and also plant varieties. We are talking about that rights as well. These are all, in fact, very, very important rights, important, let's say, also registration or registered rights. And all of those shall be seen separately. Of course, let's let me tell you now that the point which is of interest for us is actually patents. But I want to give you at least an outlook about what are the other IP rights so that you can distinguish them as well. So knowing what is, for example, a trademark gives you also an idea what a patent not is. So it is some sort of also introduction by exclusion if you want. So talking about trademarks, let's see what is a trademark. A trademark is in fact a sign to distinguish goods and services of a company from those of another company. It is normally everything that can be accepted as a sign is also accepted as a trademark. It can be a name, as I told you, for example, Nespresso. It can be a logo. It can be some forms that identify goods and or services. As for example, if you think about the Coca-Cola bottle. So, these bottles from Coca-Cola are so typical that you would even recognize that is actually a Coca-Cola bottle, even if it is not written Coca-Cola on that. So that is in fact so such a sign, such a clear sign nowadays that everybody would understand that it is from a company and it belongs to goods of services of a company. That is also so even actually a three-dimensional form can be so specific that it identifies that goods and services and it can be accepted as a sign, ergo as a trademark. A trademark shall be, of course, registered, and after the registration, uh, you might have actually a period of protection. This period of protection, let's say there is a minimum of 7 years, which has been foreseen in the international, let's say, treaties. However, most of the countries are having 10 years as a protection period. So normally, actually, you make a registration, you will have then the protection for 10 years. And the good thing about trademarks is that they are indefinitely renewable. So each time coming at the 10th year, you can renew it once more. In fact, trademarks are the only IP rights that can be renewed ad infinitum. That will not happen for the other ones. We will see further when we are talking about other IP rights. However, it is also always some if you have these types of, let's say, privilege, like being indefinitely renewable, you always have in the let's say the situation of IP rights, another thing which you have to take into consideration. The question is actually, yes, it is renewable indefinitely, but a trademark is normally only valid for a list of goods and services that is applied for. So in fact, a trademark is never general. You might have a trademark only for goods and services where you applied for. The second condition which it comes to is normally in most of the countries there is something like the obligation to use. That means, in fact, if you don't use a trademark in a commercial manner for some of the goods and services for which you registered that trademark, you can lose that trademark. The trademark shall be used, otherwise you might lose it. A trademark can be registered if it fulfills several conditions. One of the main conditions which is to be fulfilled is that the sign which will be registered with a trademark shall not be public domain, shall not be misleading, or it shall not be against morality. So, in fact, what is public domain? Every sign which is descriptive, for example, is not accepted as a trademark, because that shall be a public domain. I mean, you cannot, for example, give the trademark good water to a company who is selling water, because that would mean that everybody else has to sell bad water. So it is just, in fact, descriptive. You're describing what you are selling, and that cannot be accepted as a trademark being part of public domain. It shall not be misleading, because, for example, if you sell something, I don't know, you sell some pastries with the trademark light, and these pastries has a lot of butter in it, so it is in fact misleading. It is not light at all, and that is something which normally is not accepted. They shall not be against morality, and so on and so forth. So these are the so-called absolute grounds for exclusion. However, that is not the only reason that a trademark might be rejected. Another reason of rejection is, in fact, the so-called relative ground for exclusion. In fact, that is a ground which is thought of by the people who are dealing with that law, with the law of trademark, in order to somehow protect the users. So the idea is that, okay, if you have two trademarks which are quite similar and they are selling similar goods and services, though there might be a real danger of let's say confusion, and the one who is actually buying these goods and services might be confused and think that comes from another company. So in order to somehow prohibit that sort of confusion, this is the relative ground of exclusion which comes to play, which means, in fact, you are, if you have two, let's say, similar, it shall not be even identical, if you have two similar trademarks, the old and which are in fact registered for similar goods and services, then the owner of the older trademark can ask the annulation of the younger one. So because he can say, people might be confused and think that is they are selling my exactly the same as my let's say goods and services. So there are formalities which is needed. In fact, there is an examination which is needed in order to look about the absolute grounds of exclusion. Some, let's say, trademark offices are also looking for relative grounds for exclusion, but it's not the case of all of them. So normally, it's actually the absolute grounds of exclusion is examined by the office, and the relative ground for exclusion is the one which shall be checked by you, by the owner of the trademark. So that is of your own risk if you don't do it. Another right, which is also very important and it becomes more and more important, is in fact the industrial design. The industrial design is protecting the aesthetic outer shape of the product, the patterns or the packaging. It is just something about the aesthetic form, nothing with technical aspects. In fact, the industrial design is excluding any design which is preset by technical necessity. So if there is a technical necessity of having this form, that form cannot be protected by industrial design. It is just about the aesthetic outer shape. If there are possibilities, different possibilities, and there is actually one of them is in fact the one you think that might be the one you want, you can go for these, let's say, type of protection. The industrial design is also very, very, in fact, let's say, beloved in the past years because of the evolution we have in the high-tech industry. In the high-tech industry, for example, if you think about your smartphones, nowadays all the smartphones are doing exactly the same technical things. You can call each other with your smartphones. You can go to the internet with all of the smartphones from which company, whatever. So in such a market where everybody can do exactly the same things as the others, uh, how can you distinguish yourself from the other one? And then you see that the most important part is that what you see. So in fact, companies like Apple or Samsung or Huawei or whatever try to make a to make actually a distinction among their products and the products of their competitors by having another design, another form. A design shall be in fact registered. The registration is quite simple. Normally you have actually very simple formalities and does not cost a lot. That is a reason why it is also so somehow beloved by companies. You can have these one quite rapidly and quite cheap by simple formalities, and then you have by registration a period of 5 years of protection. Depending on the country and the law of the country, you might have the possibility of 1 to 4 times of prolongation periods. By each prolongation period, you might have actually 5 more years. So it means that in fact you have at least 2 times 5, which is actually 10 years of protection. In lots of countries, there are nowadays by 5 times 5 years, which is actually a very long time, about 25 years of protection of design. So for example, in Switzerland, in all European countries, you have the possibility of, in fact, a maximum of 5 year of protection, which is 25 years of protection. So you have, in fact, a very first registration. For that, you have 5 years, and you have 4 times each time 5 years of prolongation, which comes to the maximum of 25 years. The condition you need in order to have the industrial design is being new and having a character. So being new is something which is most of the time is defined within the country. So novelty is not seen as absolute and worldwide, as we will see it at the patent when we are talking about patents. It is something more or less local, so it is a bit different. And having a character means, in fact, that if you look at different designs, the let's say overall impression of the design shall be different. So it shall have some distinctive, let's say, signs from the existing design. So that means, in fact, just by changing a color, the design, it is maybe new because it is not identical, but it is not, in fact, a design with a character. So it is not enough to change one color to have another design. That is what is said here. So you need to do something. It shall be somehow distinctive from the existing design. Then another right that is copyright. The good news about copyright that is that you don't need any registration. So where you don't need a registration is actually you don't have to pay any registration fees, which means actually it is very cheap if you want. You have it automatically by the creation of an artistic or a literature work. It can be also actually photographic works and so on and so forth. So it is a very long lasting right because the protection period goes about 70 in most of the countries, 50 at least in some countries, years after the death of the author. So it is a very long lasting one. So I mean, it is not 70 years from the creation, but 70 years after the death of the author. So if an author, I don't know, an artist made an artistic work at the age of 20 and he lives up until the age of 90, and then he dies after that, you add still 70 years, so it is 70 plus 70 is about 130 years of let's say of protection, which is quite long one. However, in order to have that, let's say, protection, you need to fulfill also here some, let's say, conditions. The very first condition, it shall be a work of literature or art. This condition is not very hard to fulfill because, in fact, art and literature is seen as very broad. So we don't have much of negative, let's say, characteristics, so that we can say something is not art or something is not literature. So being part of literature or art is not that difficult, let's say. However, there are two other conditions. One of them is actually the creation shall be done by a human being, which means, in fact, if something is just found in the nature, it is not protected. What a human being has not done is not protected by copyright. So if you let, I don't know, a monkey take some picture, even if the picture is beautiful and it's quite nice and very beautiful view on that, and it is very well done, and I don't know, the whole thing is quite artistic. Only because it is done by a monkey, it is not protected. So that excludes also, uh, for the time being at least, every artistic work which is done by artificial intelligence. So, because they are not human beings. So, being a human being who has done these, let's say, work is one of the conditions that shall be fulfilled. And the other one is having an individual character. And this one is actually harder to explain as maybe to fulfill. In fact, what is an individual character? That is something which is normally decided by a judge. Because, as I told you, there is no registration, so no examination. So you don't know for most of the works if the individual character is given or not. And one day, if it is necessary, the judge has to decide about it. And the judge normally decides about the individual character by, in fact, considering if everybody else would have done it the same. And if the answer is yes, he would say, sorry, there is no individual character. If it is not the case, then there is an individual character. So that is quite difficult, in fact, to know in advance if some work has an individual character, yes or not, exactly because of that, let's say, situation. Everybody else would have done the same, yes or not. Another good thing is actually, as I told you, no formalities. In fact, you will have it automatically. But be careful. The copyright does not protect the content of your work. It just protects the way you did it. So, just to give you an example, if you, for example, write about a new physical, let's say, theory. Okay, so you publish your work on a new physical theory. The copyright does not protect your your new physical theory. It only protects the way how you wrote that physical theory. In fact, just the words, the combination of words and sentences, which is protected by copyright, not the content. So you cannot, in fact, and that is, again, I come back to that, what I said just at the beginning. That is just to emphasize that there is no way of protecting your idea. The idea which is described in that piece of literature is not protected. What is protected is how you realize that. The realization is protected, but not the idea. So there is no way of protecting an idea, but there are different ways due to different aspects of protecting the realization of the idea. One shall also know about the possibility of having let's say, having a copyright on software. In fact, it is a special case. The software as such is also protected. That is, the code is protected by software. So this is quite maybe quite surprising for some people, but that is actually the way people decided. Uh, in order, so some countries might have found a way to have also a sui generis, let's say, that is a right of its own, sui generis right on software. But on the international level, what you get for a software as such for the code is normally a copyright, which is not very satisfactory for most of the software writers, because what they are really interested in is not to protect just the code they wrote, because somebody else might find another way of writing a code which is not exactly the same as theirs, but they want to somehow have a protection on the effect of that software. We'll talk about the effect of that software later. I mean, really later, when we are deepening actually the patent rights in order to talk about it. So, what is in fact possible in that case? For the time being, we are talking just about software as general. It is a protection period of 50 years after the death of the programmer. As you know, it is very, very long. How many software programs you know that are living nowadays after 5 years? Ask yourself if you have still your let's say smartphone, and your smartphone is older than 5 years. Most of the time it's not the case, so you see that most of the softwares are already dead after 5 6 years. But that is actually something which is decided by the copyright law. They cannot make an abrogation to that. The condition is also, of course, the same as we had for other, let's say, other copyright protected works, which means actually being work of a human being, having an individual character, which means the software shall not be trivial. Again, the problem is actually what is trivial, what is not trivial. There you need again maybe the decision of a judge, and once the judge has decided, you know if you're copyrighted, if your software is copyrighted, yes or not. The case of copyright is a special case because there are a lot of works that might not be known without the help of other actors, like, for example, a performer or producer or broadcasting organizations. Imagine if you write some notes for a music and there is no musician who is actually playing that music. Maybe your music is not known because people, not all of them, can read the notes and can imagine how the music would be. So you need actually the help of musicians in order to make the work that you wrote, maybe actually the notes, to be known by a public. In fact, these performers, for example, the musicians, the actors, the singers, and so on, did not create that work. So they are not directly maybe involved in in that work, in that copyright. However, they have some on rights, and these rights are called, in fact, neighboring rights. So the rights of performers, of producers of phonograms, videograms, or, for example, the broadcasting organizations. In these is based, of course, of copyrighted work, but it is not directly related. Most of the time, this neighboring right is a right in time that starts at latest at the moment of the publication of that performance, and then it lasts, depending on the countries, from 50 to 70 years. So that has nothing to do this time with the end of life of the performer and so on. It is just 50 years or maximum 70 years in the time. The next topic which is of interest for us is, of course, patents. I'm going to deeper, uh, let's say, concept of patents a bit later when you're talking about, especially about patents. But for now, in order to be complete, we are talking about patents that we know what is the difference between patents and other rights we have seen. Just to make a resume of what a patent and how a patent is seen, one can say, in fact, that a patent is a technical solution to a technical question. So, exactly that resumes a lot because from that point on, you know now that if something is not technical, so it is not a patent, it is not it's not patentable. Um, these technical solution, or being a technical solution, is of course not enough. You have to fulfill other conditions, as for example being new, having an industrial use, or involving at least an inventive step. But all that might become more clear when I'm talking about those aspects a bit later. A patent is thought to die one day as well, and this day is actually 20 years after the beginning of the right, which is in fact, let's say, the day of application. So, and that is actually a very important part because you have to know that a patent will die one day. Whatever you do, whoever you are, how much you want to pay in order to keep that patent alive, it's no more possible. 20 years maximum, not one day more. Uh, then, of course, also you need to do some formalities. One of them is actually is clear. It shall be examined that this solution fulfills the conditions we set, namely actually being technical, new, inventive, and having an industrial use. And of course, another thing is that you have to pay for that. So in fact, a patent is normally applied for, examined, and so on. But and after granting, also you know that you have to pay at least an annual fee. Otherwise, actually, the patent will die. So, in order to keep the patent alive, each year you have to pay something, and this something is called annual fee in order to keep it for just 1 year. At the end of the year, you have to pay another annual fee and so on and so forth. But coming to the 20th year, it is the end of the patent. So patent will die one day. That is at least for sure. There are also other, let's say, even registered rights, uh, which are maybe not all over the world, first of all, and second, maybe not so, let's say, famous as the four we just talked about, namely trademarks, patents, industrial design, and copyright. One of those registered rights is in fact form or topographies. It is about a protection on three-dimensional structure of the layer sequence of the semiconductor layers of an integrated circuit. So it is in fact about how this layer is put together. That is just the form of them, how they are actually in different layers and different sequences and so on and so forth, has nothing to do with the technical aspect of the integrated circuits or ICs in general. So it is not in fact a technical protection again. It is more about an aesthetic form if you want. So we are going really in the direction of the design. In fact, the formalities are very similar to the design as well, and even the conditions being new and original layout is also very, very closely thought to the one we have seen for the industrial design. Also, the protection period, you remember of the protection period existing for design. I told you that it might be at least two period of 5 years, so there's 10 years up until 5 periods of 5 years, that is 25 years. And that is here not very different. It is 10 years, one period of 10 years, and that is actually also the maximum of time. So uh, one has to say that actually not all the countries might know these type of registration. And some of countries have actually the possibility of form topography registration, even if they are not really affected by that type. But I have to say that it is like most of the rights here in international, let's say, environment, that there is a reciprocity. So some of the countries actually have accepted to have these form topographies registration in order to give their own nationals the possibility of using that let's say that right in the countries where it matters, as for example in China or in United States or Japan. So even if actually your own country is maybe not very known for integrated circuit design or even also production, that might be so that your country has accepted these provision in order to give you the possibility to do it at the countries where it matters. As I told you, for example, the United States or in China or even actually in Japan. So that is one of them. Another one which is very important, maybe especially also in your country is very important, is the protection of plant varieties. That is how to protect a plant variety, and I have to say that is not about a patent. In fact, most of the patent provisions even exclude expressis verbis, which means actually in words indirectly the protection of plant variety through a patent. Because in those countries, in most of the countries, actually, you have the possibility of having a protection through these international convention, which is actually UPOV. UPOV has worldwide about 74 members, which is not that bad. It's quite good. And those countries who accepted that convention give you the possibility of, in fact, the protection of a breed. It can be actually a plant variety or breed of an animal race, which shall be, of course, new, distinct, uniform, and stable. So you have to fulfill these conditions. If you have a new variety of a plant which is distinct from what was there, it is a uniform and has a stable form, so that actually you can find it in repetitive way. Then you might have a protection on plant variety. That is actually also very important, especially for the countries where, in fact, those type of selection is very important, especially for countries which are quite active in the field of a new, let's say, agricultural products. So plant variety due to UPOV is another one, another way of registration that you have. But even if you don't have any of these registered rights, that does not mean that you don't have any right at all. In most of the countries, there is a provision or a law against unfair competition or fairness law. You can call it what you want. In this unfair competition law is in fact normally written so that you have at least a possibility to maybe have a sort of protection, even if you did not had beforehand some let's say some protection through actually a registered right. We will see what the difference is, because it might even seem that it is enough. We will see if it's enough or not. Uh, let's look at one of those provisions in, for example, in European law. In European laws, you will find something like that. It said, for example, that is acting unfairly, in particular, somebody who, and then he says who is acting unfairly. For example, somebody who uses in an unauthorized manner a work entrusted to him, for example, offers, calculations, or plans. So you have been given something in trust and you use it. Of course, you should have known that you are not allowed to use it because it was given to you in trust, and you use it, so it is at least unfair. Okay, so that is something you would say, "Oh, I agree, it is like that." Then it is also acting somebody who exploits works result of a third party, such as offers, calculation, or plans, although he who should have known that it left or has been made available to him without any authorization. So again, somebody stole that idea, that plan, and so on, and he gave it to you, and you knew that it was stolen by this guy, and it is not authorized to use it because it was stolen, but you use it in anyhow. Of course, you are not the thief because you did not steal it, but acting like that is seen as to be at least unfair. So it is in fact also here an unfair act if you use it in that way. Then, and the third one that is very interesting for our case, it is said that somebody acts, it is actually acting unfair, somebody who takes over marketable works results of others without adequate on expense and only through technical reproduction processes. So that is very interesting because it says, in fact, if I have, for example, an invention and somebody is doing just a copy through technical reproduction processes, then he's acting unfairly. So I'm protected because he is, in fact, just copying me. So it seems that, in fact, having this law, you don't need any registration, isn't it? So, I mean, the law says actually if you make the invention and somebody just copies it, it is he's acting unfairly. So I'm protected. I don't need any protection. Isn't it like that? Not that, not in that way at least. It is not quite what I am going to. I actually I pretended it to be. You have to read actually the whole sentence as a whole and try to understand what it says. I put something here in red in order to make clear what is really very different to that what I say. In fact, it says it takes over marketable works. So you have to show that your work was marketable. Then, without adequate on expense. And what is an adequate on expense? That is not clear. So there are two very important parts. You have to show that your work was marketable. And another very important part is, in fact, that who has the burden of proof? If you have a registered right and somebody infringed your right, then you go and you say, he is infringing me. And now he has actually to show that he's not infringing you. Okay? In that case, the burden of proof is on the other side. Where if, for example, you are in fact using just unfair competition law, the burden of proof is on your side. So you have to show that you were the very first one, not him. So you have, in fact, to really bring a proof that you were the first one on the market. Then the second one is actually you were on the market. It was marketable. It is not just an idea you had. You had really something which was marketable. You have to prove it. Then you have to prove it that he did not do it with his own adequate expense. So how much adequate is adequate? That is actually a judge to decide about that. But still, you have to show that he did it just by copying it. So you see, to make the proof of all that, it might be very, very difficult. While having a registered right gives you the possibility directly to use it against third parties who is infringing your right. So I don't say that is bad. It is good to have that type of protection. That means actually sometimes you don't have any other choice as using the unfair competition law if you have it in your provision, but be careful that is not a complete protection. That is just actually a way, as last way that it remains if there is no other way of protection at all. Then unfair competition law is also very different in different countries. For example, the unfair competition law in Europe knows also something against deception, which says, in fact, unfair and unlawful is any deceptive behavior or any behavior otherwise in breach of the principle of good faith, or any business practice that affects the relationship between competitors and or between suppliers and customers. So this is also another part which you might find in many European countries, which says, in fact, you can make an advertisement for yourself. You can make an advertisement and praise your product, that my product's good, without any problem. That is the goal of an advertisement. But you are not allowed, for example, to make an advertisement and saying other products are quite bad, they are awful, they are disgraceful, or actually making these type of deceptive behavior. It is not allowed. As I told you, different countries, different laws. In United States, for example, you don't have these part of the provision. So in United States, you can make some comparative advertisement. There are actually some, in fact, very known advertisement from United States where people are saying, for example, Coca-Cola is bad, drink Pepsi-Cola or some things like that. So these type of advertisement, for example, is seen as being deceptive in Europe and they are not allowed. So that is also another part of unfair competition law and provisions which might be different in different countries. Now, the point is actually, are there the only ways we know to protect our ideas, our inventions, and so on? Is it all? Of course not. I'm sure all know at least one other way. The very first way it comes to your mind when you are thinking of your ideas. Of course, keeping it secret. To keep something secret, of course, it is very, very let's say trivial in hindsight of protection. Of course, everybody thinks about it, but you have to keep in mind that it is only effective for certain circumstances. Keeping secret the invention you have maybe in the form of a very simple mechanical device has no sense, because the very first part you sell, the one who buys it can make actually reverse engineering in 2 minutes and he will tell you how it works, and then it can be copied. So it is of no sense of when you keep secret that type of, let's say, inventions. So, but it is very, very effective if it is about a method. For example, the method of production of a product. When you buy a product, you cannot see on the product how it is produced. So the method of the production or any other method might be kept secret quite effectively. So think about it if it is about a method, about let's say an improvement in the method of production. That might be kept secret quite good. If it is about extremely complex products, so that you need the work of a let's say an engineer for at least 2 years to find out how it works. I mean, if you pay the salary of an engineer for 2 years, it is so expensive that it's actually maybe cheaper to have a licensee. So in that case, even if it is a mechanical, let's say, innovation, it might be good enough if you keep it secret. If it's about niche products or if it's about service procedures, all that are, let's say, possibilities where the innovation might be kept secret effectively. For all other cases, you shall be careful about that, and there are, in fact, maybe not that effective. So maybe you think about also a combination to patent what is known easily after the very first time you sell that, and keep secret one what can be kept secret. For example, your know-how that can be kept secret. Good thing about actually keeping secret is that you don't pay any annual fee for that. You don't pay anything to any instance for that. So it seems to be very cheap because that does not cost anything. But it is just too, let's say, a little bit too naive to think that you don't pay for that, because keeping secret, in fact, has other costs. Think about the mobility of the employees nowadays. The employees are changing workplace quite easily. It's not like ancient times. So you have to pay a bit more to keep people longer in order to make sure that the knowledge is not gone by the people or with the people when they are going to another company. You have to distribute that knowledge so that not one person can have all the knowledge and he goes away and he brings or takes all the knowledge with himself. So you have actually investment to do in that case. So you have to pay for that. Then bad thing about secrecy is that once it is disclosed, it is public. You cannot undo the knowledge. When the people know it, you cannot go to them and say, actually, now you have actually to erase it from your head. That is not possible. So once it is known, you lost it, and you cannot, in fact, do anything about it. Another risk is that somebody else maybe can patent that innovation, and then he will be the one who has the patent and who has the exclusivity. Of course, you might have the possibility to continue to carry on in a restricted way, but at least you will have this possibility. But in order to have that possibility, again, you have to make sure that you document that it was your trade secret. So once it is patented, at least you can go in front of the judge and say, look, it is documented. It was my trade secret before he actually patented that. So the judge at least accepts that you can continue, you can carry on without paying, let's say, actually being actually hindered to do so. Of course, in a restricted way, but at least you can do so. And then make sure that actually you document everything, because if you did not do that thoroughly, you might lose also a part of your freedom to operate, because everything which cannot be shown that it was your trade secret then is under that patent. So again, things shall be done so thoroughly so you have other expenses to do to keep it secret, as you see. Then the point is, in fact, that he will have the exclusivity in front of all other people, but not you, even if you were the very first one who had the idea. Okay, so that is actually the risk you might have with secrecy. Then you might also find another way. For example, you think, uh, I don't want to patent. We will see actually patenting might cost a lot. And say actually that is a lot of cost and don't want to patent. So at least make sure that nobody else can patent it against you. In order to do that, you can make a defensive publication, which means actually you publish that innovation in advance in order to guarantee the freedom operate and to kill the novelty for anybody else. So these defensive publication is also a sort of protection, if you want, by hindering other people to patent by destroying the novelty for everybody. Or, for example, you might not plan to use it now, but you are afraid that maybe somebody else would make a patent to make some blockade against you. So in that case, in fact, a defensive publication would help you to come out of that situation for a future blockade. So you make actually a defensive publication uh, in order to destroy the novelty for anybody else and to make sure that nobody can make a blockade against your further development. So all that had been said, in fact, a very important question is actually, do I need really any IP right? Because that is a question of cost and benefit. IP rights are in general only costs. You have to pay for them. And it makes only sense to pay for them if you have some benefit out of it. In order to have the answer to the question if you shall apply for an IP right, yes or no, you have to ask yourself the right questions. Some of the main questions actually you might ask yourself is here, I put them together for you. For example, one would be actually which IP right would apply. So is it a technical invention? In that case, it's a patent, just a form, or is it about for example, name or logo to sell my products and services? That is actually a trademark, and so on and so forth. Then one real question actually, where is or where are my main markets? So I know that almost all the registered rights are under the principle of territoriality. So I have to make the decision in which countries do I need that one, which countries do I need my trademark, in which countries do I need a patent and protection, and so on and so forth. Then another question, even if you decide not to apply for, let's say, an IP right, this one you have to ask yourself, do I infringe existing rights? Having an IP right is something I can decide. However, if there is some existing right, IP right, I shall be careful about that. So freedom to operate is the most important one. Then which are the protection maybe I need? Did I think about IP in the contracts? How about the budget? How much money do I have? Then who is responsible for that, and who is actually in charge of surveillance, because it is the IP is an ongoing system. You cannot stop at a moment and say, actually, I am done, that is everything good. No, you are always in front of the next step, and you have to go over it over and over again. Then, in order to define your strategy, of course, you need, for example, a very basic, let's say, decisions. For example, what shall be protected? Do I need to protect the whole or just part of it? Or, for example, then what is protected? Is it about a technique? Is it about name of firm and product? Or is it about the form that I want to protect? Shall I have one protection right, or do I need more than one protection right, depending on actually which aspects do I want to in fact, protect and so on. And then you have to define your strategy due to your market, for example. Do I need a intellectual property right? Or maybe it is enough just to use the unfair competition law. Can I keep it secret? Shall I do actually a publication in order to have a protection through that publication? Then another question is, in fact, okay, so where shall I protect that? Is it enough to do it just in one country? Or maybe shall I make an application in a regional way in several countries? Or even actually, I do need an patent all over the world, an international protection. Okay, of course, everybody needs and wants the biggest protection of all time, but can you pay for that? That is a question you have to answer while thinking of the cost. For example, the patent cost in just one country for the very first 10 years, let's say in Switzerland, you have patent cost about 10,000 US dollar for the very first 10 years. So it's not actually the cost you pay at the beginning, not at the end, but in a cumulative way. So on and on you pay for that. About $7,000 you pay for the work of a patent attorney to write the patent, and you have about 3,000 US dollar of fixed costs of, for example, application, examination, and annual fee for the very first 10 years. Then, if you go, for example, for a regional patent, you take into account somehow, let's say, not only the Switzerland, but also other European countries, like patent through European Patent Office, using let's say, or design, designating Switzerland, Germany, France, Great Britain, Benelux, and Italy. These are three countries. Then you have somehow cost about, let's say, 40 to 50,000 euro for the very first 10 years, from which half of it are the fixed cost, another half are the costs you have with your patent attorney for translations and so on and so forth. Then just add to it through a PCT, that is an international application. Add to it just United States. You have exactly the same countries as before, and you add through an international application, which is offered by WIPO, that is World Intellectual Property Organization, this possibility, and then you will have cost about 100 to $150,000 for the 10 years. However, $150,000 might sound a lot of money, but you have to take into account, okay, for that amount of money, I have the protection in a market of more than 300 million people. If in 10 years I succeed to, let's say, sell 150,000 pieces, and for each I receive only $2, then I have the money and I doubled that money. So again, cost and benefit, what would bring, and that is actually what you have to take into consideration before going further, before starting the whole application procedure and so on and so forth. So what I mean is, and I'm going to finish that whole thing now, is what you need in any case is an IP strategy, not an IP. You might live in a strategy without any IP, without any own IP. But even in that strategy, in your own IP strategy, you have to make sure you are not infringing existing IP rights of the third party. So even in that case, you shall care for IP, not for yours, but for third parties. So the idea of having an IP shall come out of a strategy, or maybe not. If you don't want to have the IP, also these decisions shall come out of your strategy, and you have to make sure that you know what you are doing. And that is the most important message I want to give to you. And I want to thank you with a international registered trademark, merci, which means in French, thank you. It is actually very known chocolate all over the world, and I hope uh, at least I could make clear some points of what is IP, what are the main IP rights, and what is the most important in the whole, let's say, IP system, namely having an IP strategy. Thank you all.